Hi, this is Carlos Romero, the Payroll Pro from Heartland, and I'm here today with Sanjay Sabarwal from Sabarwal Law. And today we're going to cover AB 685. But before we do that, I want you guys to, if you have any questions or you want to want us to reach out and discuss anything in particular, please click down below and just enter in your comment or send us a message, and we'll make sure to make that one of our topics in the future. So anyway, so Sanjay, let's get back to AB 685. What can you tell me about this imminent hazard to employees thing?
It's a scary name when you say it. And one of the reasons, Carlos, I was telling you I wanted to cover this topic first is because this deadline is coming. This law goes into effect January 1st of 2021. Hard to believe that we're finally going to be done with this year, but new laws are coming that basically tell us what's been going on in this world, especially this year. This particularly has notice requirements for when you find a business owner finds out about a COVID-19 exposure. So basically, AB 685 has notice requirements that employers now need to follow once they have what is called a qualifying individual, and you have a business day to give notice to your employees. So what is a qualifying individual? Part of it's commonsensical. It has to be someone that gives you notice, a written notice from a doctor or a result of a test, letting you know, hey, I contracted, or I've been taking care of someone that has contracted COVID-19. Once you have confirmation of that, now you'll have one business day to let all your employees know what's going on.
So I understand correctly. So once you are notified that there is a qualified individual, meaning it can be a worker, it can be a guest, it could be a client, it could be a customer that notifies you that they have contracted COVID or has someone in the household that has COVID, then you need to notify your employees about this, right? Okay.
And you have to basically the notice you have to provide. You obviously have to take off all the identifying information if it is an employee, because obviously you do not want to single out that employee. However, when you do send out the notice, you must let your employees know about the workers' comp again. You have to let them know if there's any COVID-19 related leave, if you offer any paid sick leave, as well as the employer's anti-discrimination and anti-retaliation policies. Because guess what? Now this would be treated as a protected activity or a protected person. So if you decide to retaliate and terminate that employee for being positive for COVID, you could be facing a wrongful termination action. It's really important for employers to keep that in mind. I get this is scary, but because of this, you have to be careful how you proceed.
Okay. So to be clear, after you're notified 24 hours, you have to notify employees to provide them information on what they qualify for, right?
Yes. And the written notice can be pretty straightforward. I don't recommend this, but there are employers that communicate with their employees via text, can be email and or personal service.
Okay.
So as long as you can, because you're going to have to explain to someone, an outsider, that, hey, this is how I normally communicate with my employees, and it can be reasonably anticipated that they're going to get it within one business day. The reality is email and text are easiest because everyone has a smartphone and everyone has access to text messaging.
Got it. Okay, and then what happens next?
So then you also have 48 hours to report this to the California Department of Public Health. And this can be a little tricky in the sense that you must report them. I have to warn employers that if they do not, there could be consequences. But more than important than that, now OSHA has the authority to shut down a work site. Normally, they have 15 days to, you have a chance to rebut the assumption for any other violation if it's an OSHA violation. Because of AB 685, now they don't even get the 15 days. They have to correct those issues right away, and employer doesn't have 15 days to rebut the presumption. And if they don't, OSHA can and OSHA considers it to be imminent hazard, OSHA can shut the business down. And that's the part that's a little bit more egregious, has teeth in it, and that's what's scaring a lot of people.
And what would happen if an employer did not notify OSHA? What is the ramifications there?
If it's determined that OSHA finds out that this was an imminent hazard, it's a $25,000 per citation per violation charge fine. So the fines are pretty expensive.
and really to protect your employees and to protect yourself, it's really important that you comply with the OSHA requirements and you report this. So we want to make sure people understand that this is for public safety, for public health. It's important that this happen. So please make sure that if you have someone that reports, that you're reporting it to OSHA, and that way that's handled the correct way.
Finally,
they'll make a determination for you.
Finally, I will add in a slide explaining AB 685 a little bit more in detail. We'll add that slide to the end of the video so you can follow that, and as well has some links that you can follow as well.
Perfect. So that's AB 685. Hopefully that's helpful. And if you have any questions, please, like I said, write it down below and we'll respond. All right. Thank you.
Thanks, guys.